Hey, Whitney here. Welcome to the Passive Investing Made Simple show. I'm your host, Whitney Elkins Hutton, Director of Investor Education here at PassiveInvesting.com. And I'm excited that you've joined me today. We do this show live every Tuesday to help you learn the ins and outs of passive investing so you can go into your next deal with confidence. And so if you haven't done so already, make sure to check us out at passiveinvestingwithwhitney.com. There, I've got some free goodies for you that you can't find anywhere else on the passiveinvesting.com website. And you can also connect with me if you'd like to talk about all things passive real estate. Again, that's passiveinvestingwithwhitney.com. Now, today we're going to be talking about some things not legal. I'm not a lawyer, but beyond real estate planning, or excuse me, beyond estate planning for investors. And so we're going to be talking about on a high level about the kind of a legal plan that you should have in place, but also once you have that formal documentation in place, what else do you need to do as a passive investor to truly safeguard your wealth? Now, if this is the first time we're meeting each other, again, welcome to the Passive Investing Made Simple show. I'm Whitney. This is the whole reason why I invest in passive real estate. These are some photos from my most recent summer trip. To Glacier National Park. We had an amazing time, but this is really why I invest in passive real estate, why I invest in real estate in general, is so I can have the freedom and time and choice to travel and spend it with my family. I work hard, we play hard. And so, but this is what it allows us to do. Now, for you, these photos might be very different. You know, we are recording this at the end of July 2024. Maybe you're at the Paris Olympics right now, or that's your dream travel, whatever it may be. I hope that as you scale your passive portfolio, you get to experience the time and choice freedom that my husband and I have gotten to experience through scaling a passive portfolio and active real estate portfolio of over 6,500 residential units, 2,200 self-storage, and 15 express car washes. But that's not the numbers we should be focusing on. It's the result. Is how can you scale your investments as such that by the end, you have 100% control and choice on how you spend your time. And we can help you do that here at PassiveInvesting.com. We've deployed over 308 million through our Rehab Wallet lending arm. And again, this is July 30th of 2024. If you listen to this by July 31st, we do have an investor bonus and investor incentive on our PIC real estate debt fund. But we've also deployed over 104, or excuse me, purchased over 104 billion in assets in our equity investments of multifamily, express car washes, and self-storage, and we have strong returns to our investors. Now, this webinar, we are going to talk about some things in the legal realm. However, this is not financial advice, legal advice, or tax advice. So take everything that we cover here today back to your investment team before making any sort of decision. Now, let's talk about the 3 phases to passing on wealth. Now, most people, when they think of passing on wealth, they just think of how can I get a will or trust in place, call it a day, I'm good. That is one of the phases there, but it's a little bit more in depth than that. What are the actual 3 phases here that we need to think through in order to safeguard our wealth and ensure that it passes on to the next generation as you intended it to, with intentionality? So phase 1 is plan for your incapacity. Now, the problem is here, the reason why most people don't actually complete phase 1 appropriately is nobody likes talking about dying, or you think it will never happen to you. So you procrastinate. You think about, why do I need to put in place a living will, powers of attorneys, healthcare directives? Why do I need to do that now while I'm young and healthy? I'll worry about that when I get into my 50s or 60s, and it may be too late. So the solution here is to actually take time. It doesn't have to take long. Take time now while you have your health and mental capacity about you to get that living will in place, to get the healthcare directives in place. The reason why you want to get these 2 puzzle pieces in place right now is because you now, if something happens to you, if something, maybe you slip, trip, and fall and are, incapacitated for a while, you get to actually direct how you would like to be taken care of, how you would like your estate to use its funds to take care of you. Okay. You're making those decisions now while you're of sound mind and mental capacity. And you can put durable power of attorneys in place to designate people in your family or friends to make decisions upon your behalf, things that maybe you couldn't foresee. Again, you're doing this while you're a sound mind and body. Now, these aren't these can be very limited power of attorneys, like medical power of attorneys, where the decision-making power is very limited. They could be general power of attorneys where you're giving over all sorts of power over to somebody else. Okay, again, you're going to want to talk to a lawyer, consult a lawyer, and make sure what's appropriate for your situation. Okay. Another part of the solution is, while you're of sound mind, is to think about getting some sort of life insurance in place. Now, we talk a lot about permanent life insurance policies here, such as whole life policies, and how to use those as to boost your cash flow returns. There's a lot of other perks to it, but it doesn't actually have to be permanent life insurance. Maybe it's even just a term policy. Okay, something that you could leave to the next generation, but also it could help offset cost immediately right now. Okay, and then make sure that you have rounded out your board of advisors as part of the solution, this planning for your incapacity solution. Okay, that you have somebody that if you slip, trip, and fall, you got in a car wreck, and all of a sudden you're in a coma for 30 days, 60 days, that your spouse could turn to, your partner can turn to, your family can turn to talk about what's legally appropriate, accounting, what's going on with various investments and businesses, and then maybe even from a financial perspective, like a mentor or something like that. Okay. Now, we talked about the problem, the solution, what you need to have in place. The process is going to be fairly simple here, straightforward. Okay, for the living will, healthcare directives, and the power of attorneys, you're going to want to consult a lawyer. There are websites out there like nolo.com, Rocket Lawyer, stuff like that. Those are potential there, but consult a lawyer to see what's appropriate for your situation. Also, on the insurance piece, you can contact an insurance broker. Now, they're not all created equal. You feel free to reach out to me directly if you need a suggestion or two, especially for the permanent life insurance piece. But contact somebody, an insurance broker. Pretty easy to get that term policy in place, pretty inexpensive. Okay, that'll at least pass wealth on to the next generation. But there are potentials, and we're going to open up some more conversations on our masterclass here about opening a cash flow life insurance policy. That could be another option. Okay, and then again, fill out those board member seats, if you will. Make sure that you have an accountant in place, somebody who's doing your taxes, okay, or understands them, and that you have a financial mentor in place. The result of phase one, if you do all these actions in phase one, is that you're going to keep your health issues from depleting your wealth, right? And here's the thing, this is phase one. Okay, this is before getting the will and trust in place. This is how can we keep your health, those unsuspected health surprises, from draining your wealth. All right, now we're on to phase two, creating a plan for your estate. And this is where a lot of people actually start. But here's the thing. The problem is most people actually think their estate is not complicated. Okay, so they don't want to pay the expense of setting up a trust or even talking to a lawyer about it. They just think everybody knows what they want. And so when they pass away, they'll just be able to delegate assets, according to a very simple will, maybe even something written on the back of a napkin. My uncle was a lawyer, an estate planning lawyer for several years, so he's seen it all. And he just thinks that he's seen these things, and he thinks that the people thought that the estate plan was pretty simple and the kids wouldn't fight about it, and that's actually not the case. So I'm going to break it up here. We're going to go through the process here, and then I'm going to help you think about the solution, because there's a couple of different things that we can do for the solution as far as wills and trust, okay, for creating the estate plan. But the process here, everybody should be taking care of these steps. One, making sure, even today, you can take 30 minutes today, put it on your calendar. Go into all of your accounts and then make sure every single one of your accounts that possibly can, bank accounts, retirement accounts, life insurance, anywhere, investment accounts, anywhere that you can assign a paid on death provision or a beneficiary, get that done now. It doesn't cost you anything other than 30 minutes of your time. Okay. And then all of those, if you have those paid on death provisions, in place, all of that should circumvent any sort of probate. Okay. So yay, we've taken those assets out of play should something happen to you tomorrow, right? Next, if you have other assets like rental property, your house, cars, stuff like that, consult a lawyer and work through the framework I'm going to show you on the next page to decide if a will is appropriate for you or if a living trust is appropriate. If you choose to do a trust, make sure you transfer the assets into the trust. Okay, and then we're going to go into phase 3. So let's take a look at the solution really fast. How do we decide between a will or like a revocable trust or a living trust? Wills, they tend, the assets are actually owned by the estate. Okay, so if something happened to you and you have a will in place, if you passed away tomorrow, all of your assets would move into the estate. So essentially, the heirs would have to, or the executor would have to open up probate and get the assets dispersed. So essentially, your heirs have to open up a lawsuit against your estate, is what's happening here. Simplest terms. Okay. Now, this is a very public process. And while setting up a will up front isn't that expensive, $300 to $600, on the back end, the estate might be paying $17,000 to $33,000 or even more, depending on the complexity, to actually get those assets dispersed. So it could actually drain the estate pretty quickly, depending on how much you have in there. And if you have kids, especially kids under the age of 18, that a will actually doesn't establish guardianship of any dependents. All right, now you can add additional paperwork in order for that to happen. Totally easy to do. All right. Now, this is a good option, if maybe you just have a car that goes through or like one checking account that can't have a paid on death provision. But for us here, we are investing. We have assets. We don't want everybody and their dog knowing what our assets are and what our business is. So talk to your lawyer and consider setting up a revocable living trust, okay? Because when you move your assets into a revocable living trust, it does take a little bit of expense up front to do that, maybe $3,000, maybe $4,000, depending on the complexity of your estate. But there's no probate needed whenever you pass away because you don't own the asset. The living trust owns the asset and the trust doesn't die. Okay. And so when you pass away, the process remains very private. Okay. Meaning that there isn't all of this, public record, things going into the newspaper saying, hey, somebody passed away. I remember when my mom passed away, I had to open up probate and I had to I had to file her obituary. I then had to make public in the newspaper that I had gotten my letters of testamentary. So if there was any creditors out there, then they knew who to contact. I had then to, contact every single creditor and say, hey, if you got a judgment to put against the estate, let me know. I can either settle it for you or you can go file against the estate. And so that took 120 days. And then I had to put another thing in the newspaper, letting everybody know, hey, I'm closing the estate, by the way, as the executor. You've got another 30 days to let me know. And so it's a very public process. Okay. Okay. You can sidestep that with a living will or trust. And then also with a living will or living will or a living trust, or sorry, not a living will, a revocable trust or a living will, same thing. Guys, I'm going to rewind that 2 seconds. I've had a cold. Words are hard for me today. With a revocable trust or a living trust, that trust also can establish guardianship for your dependents as well. So you can have that all nicely laid out. Okay. Now, upfront, a little expensive. On the back end, you're going to save some money here because maybe there's zero cost to disperse assets. I put up to 20K. That's what I found in my research. And this is for estates potentially over like $30 million that it could cost 20K to settle some of this, depending on the complexity of the estate. But for most living trusts, you're going to be zero, maybe a couple $100 up to maybe $1,000 in order to settle the trust. All right, so let's go back. Here in our process, the result is for phase 2 is now that you have a plan in place for passing assets on in your estate. Okay. And if you use a trust, you actually have greater, you can have a greater control of the wealth plan for future generations. Right. And we're going to talk about that in our phase 3. Okay. Phase 3, this is something that most people that I've worked with don't actually do. They don't train their executors or their heirs very well, or they don't have a comprehensive plan for this. So once we've planned for our incapacity, that should take us about an hour or change to get done. Okay, then we get phase 2 in place. We get that will or living trust in place, okay, with the help of an attorney. That's phase 2. Now, you might be in for a couple hours of a lawyer's time to figure all that out, but that might take 2 or 3 weeks to get sorted out, not very long. All right, now we can move on to phase 3. That's training the executors and heirs. And the reason why most people don't do this or don't do it very effectively is that they think that people know that, for one, that having a will or trust is just going to take care of everything, right? That somehow magically their heirs know all of this, okay? Or they think that people just know how to steward their wealth, right? And that's the fact that nobody does. So the solution is to create a plan, train to the plan, and plan for the plan to change, right? So how do we do this? So we're going to create what we call our CYA plan, okay? That's what I always kind of joke around with it in our family, or the I love you plan, okay? And notice here, the first step is make sure that all of our accounts have paid on death provisions and designated beneficiaries. Why? Because if we forget something, we want it to bypass probate if we possibly can. All right. Then we're going to train the executor. We're going to train them where that living will is, or excuse me, where that will is. Where's the living trust? Where are all the asset documents? Okay. You don't have to give them access right now, but where is all that? Okay. Do they know how to access that? Then you're going to spend a little bit of time with them. You can either talk to them one-on-one or even write letters to them and attach it to your will, attach it to your trust, explaining the rationale of why you set up the will and the trust the way you did. Okay. Now, if you made any decisions that were a little, off mark, so and say you have 3 kids and you didn't like leave a third, but instead half and a quarter to the kids, make sure that you leave letters to the heirs for their rationale. Okay, that can keep a lot of your heirs from battling each other in court. Okay, because now they not only have the legal documentation, but they also have a letter that you wrote in sound mind telling them this is why you made the decision the way you made the decision. Okay, so and that can all go with the executor. All right, you can fully inform them. Now we got to train the heirs. Okay, and I'm going to spend the rest of today's presentation just going over some resources for you on how to train your heirs with the next generation. But for a lot of people, this is the most important part. They may not even want to leave money. But we want to leave a good solid plan in place on how we created our wealth. What are the goals, the expectations, that we should hold ourselves to that can help us lead to build wealth. So you can write a purpose statement and attach it to your will or trust. And in that purpose statement, especially if you're going to leave any sort of assets or money, state what your goals are, your expectations, the rules for the wealth transfer. But be flexible in there, okay? Allow for contingency plans because we certainly can't foresee what's going to happen in the future, okay? But then in this purpose statement, this is a great opportunity for us to communicate values, traditions, mindsets, skill sets, network, okay? We can actually make this like a training document for our heirs, okay? I have mine on a Google document and it links out all these different resources. And so if something happens to me tomorrow, my executor and my heirs can actually like take the document and they know exactly what I foresaw for this wealth transfer to happen. Okay. And then you can incorporate in real life training through games, books, documenting your journey, getting people involved, getting your heirs involved in your business today. Now, here's some resources for you to share. Some books that I like. I put Money for Tomorrow. That's a book I recently wrote with Bigger Pockets. Here, that's like the one-stop shop for me. It's the plan I wish I had in place when I started my wealth building journey. Okay. But that's probably for, people that are like, late high school on up, but if you got kids, this is something my daughter's reading right now. She's 12, From Piggy Banks to Profits. Very simple book, but it goes through like just how does money work? How does banking work? How does investing work? And at the end, they're actually executing on getting invested into assets. And then we've got our fan favorite here, Richest Man in Babylon. You can't go wrong with that. Other things that you can do with like kids, or even teenagers, there's cash flow for kids. That's great for younger kids. As they get older, they might understand the game Monopoly. And then as they age too, they might like card building games like Catan, Seven Wonders, Dominion, that teaches a lot about resource management. And then a game that we love playing with our daughter is called Thrive Time. It's the next evolution of cash flow for kids. So it's in between cash flow for kids and then just regular cash flow game, but it's called Thrive Time. Okay. And then we can put our heirs into real life situations. If your child's at home, we can create a value economy in the household rather than doing chores. We can help them invest in stocks at a very young age. And maybe instead of buying their toys, let's invest in the stock. And a good example is my daughter loves Squishmallows. We've got a lot of them. And I'm like, hey, let's invest in the Squishmallow stock. And then whenever you get paid from the stock, that can pay for the next Squishmallow if that's how you want to spend the money, right? But most importantly, with this life experience, okay, let them fail early and often so they can learn these lessons with your guidance at home. And hopefully it's less painful whenever they go out in the real world. And then for you, keep a journal, of of how are you learning? What books are you reading? What values are you uncovering for yourself? And keep this all documented in your purpose statement. And then one thing that have thought that has been great value for our family is to hold what we call family board meetings. And so if you've never read the book Family Board Meeting by Jim Shields, this is an amazing book of just like how you have 18 summers, but how to create lasting connection with your kids. But there's also a very cool through line through here on in these board meetings, what kind of skills are you trying to connect and teach to your kids? Financial skills, communication skills, personal development skills. And so these are the skills that I pulled from the book, financial intelligence skills that aren't being taught in school that we should teach our kids as we can through these board meetings and our various interactions, various relationship skills that may or may not be fully developed for them, like in school, and then personal development skills. All right, guys, we're about to open up our session to Ask Me Anything, but I do go over a lot of this material in my book, Money for Tomorrow, How to Build and Protect Generational Wealth. You can order that on Bigger Pockets or on Amazon. There's your QR code below. And if you want to dive into how passive investing can help you scale your real estate portfolio so you can be in the amazing seat to pass on some wealth building assets to the next generation. Make sure to connect with me at passiveinvestingwithwhitney.com. Here's all the goodies that you get here at that website. All right, guys, we're about to start our Ask Me Anything session. Sorry, guys, I have a bit of a cold, as you can tell. But my first question to you is, what did you love, and what would you love to see in this type of presentation? What were your ahas? And if you've got a question, make sure to pop those over into the Q&A box. I'd love to answer those. All right. No questions coming in yet. Chris says, thank you. Yeah, my pleasure. But again, was this useful? I'm all the time trying to create new content for you guys that's going to impact your, not only your investing, but your financial journey. And I need feedback from the audience. Is this helpful? Question came in. Can I repeat the recommendation online for lawyer services to build a trust? Okay. So I just what I said is that I know there's websites like Nolo, like Rocket Lawyer, stuff like that that you can use to put together legal assets. As far as recommendations, I personally use KKOS Lawyers. That's Mark Kohler's legal firm, and so that's who I use. I've been using them for 8-9 years now. There's a wealth of like legal firms out there. I've interviewed a couple different ones on the Passive Investing Made Simple podcast, so you can go back and check in on those. But you want to make sure that I know there's now kind of the fintech has gotten into the legal space, and there's a couple websites out there that I think one of them is Legacy. I have heard them recommended, but I've never tried them. But it's supposedly free trust. I know like companies like Legal Shield will do free wills. If you sign up for their membership, even just for like a month and then cancel it, you're kind of going to get what you pay for, I think. So if you're like young and in your 20s and you're not married and you don't have a spouse, you don't have a kids, you don't really have any assets, maybe those are kind of worthwhile just to have something in place. If you're older and you have like a spouse, maybe siblings, a business, and maybe like a couple of dependents, I would spend the time and talk to a lawyer. Like I said, on a trust, setting up a trust, you're probably going to be about $3,000 to get that going. A will, I would imagine, would take like a couple of hours of a lawyer's time. But what you're trying to do is keep that wealth from being eroded through the probate process, as well as from any sort of infighting with family. So hopefully that helps you out. Thank you, Winnie. This subject reinforces my need to follow through with this plan and stop procrastinating. Yeah, like I said, some people love using kind of like those free websites, setting up a living will, health directives and power of attorneys, pretty simple, pretty straightforward. You can just get something in place and then research a lawyer, get that process going. For me, when I did my trust, I got the whole package. they did the living will, the healthcare directives, power of attorneys. I got the living will, I got a pour over will, I, got everything, kind of like the whole coup d'etat. So that can be something, that can, really take a lot of brain power off your plate. Like that, train your air suggestions and leaving letters. Those are aspects that are not emphasized by lawyers. Yes, I thank you for mentioning that. That is something, you know, uh, I will say, um, it's not going to keep people necessarily from trying to sue, or trying to like contest a will or anything like that, but it's going to make it really difficult for people to contest a will, like if you clearly explain in sound mind why you made the decision. We went through something similar in my family. When my grandfather passed away, there was just a teeny bit of money, it got divvied up, but my dad got skipped. My dad had already passed away, but my mom, being his spouse, should have gotten his portion. But my grandfather had left a letter. Now, granted, probably should have been changed, but he had like left a letter saying, "Hey, I'm skipping you guys because you have a lot of health conditions. We're going to set this up a different way. And we don't want, any money to flow to you because we think that, from the outside in, what you've shared with us, there's a lot of financial issues and then it might get eroded in bankruptcy. So, hey, we're going to do something a little bit different here." But he outlined that had they just had the will, we all would have kind of like panicked and gotten like, my grandfather, why the heck did he do that? But he left a letter attached to it, and we were all able to go, oh, okay, that's what he meant. And he was a sound mind and body at that point in time, so it made sense. And I've heard of letters, helping ease that kind of transition process for a lot of people. Do you have any suggestions to bring this up with older parents who have a lot of anxiety about their limited wealth? My husband and I need to discuss this with my in-laws, but they're very nervous about bringing it up. You know, mean as far as estate planning? Uh, estate planning, you know, it's a personal decision. Like this falls into the realm of personal finance, and personal finance is very personal. I would say, I've been in a same situation probably for the last 5 years, with my husband, and just saying, "Hey, you need to talk to your parents. By the way, they didn't have a will." I was like, "They need to have something." Like, otherwise, it's going to be like completely nuts when they pass away. And they have like, again, they think they have a very simple estate. And I'm like, it is. But if you don't even have a will in place and you pass away without a will, without a trust, now the laws that you're going by are the state laws. And if you don't want the state to decide what to do with your assets, get a will in place. Okay. There is always a plan. Okay. We just want to make sure it's a plan that you like. All right. So yeah. I would ask questions of what more along the lines of like, what's keeping you from making, sitting down and getting a simple will in place, and find out what the hesitation is there. And quite honestly, like maybe take them for a walk or take them to their favorite place. Like, don't make it like a sit across the dinner table thing, but just like, hey, we've opened this conversation before. I'm really curious. What's the hesitation here? So don't make it about the will, make it about like what the hesitation is. Maybe they don't want to face dying. Um, maybe they've had a bad experience, in their life, and that you don't know what it is. But I would start the conversation there. And I think starting those conversations, even though your husband might be nervous to start these conversations, I think you're coming from a place of love and support to open up these conversations, because the alternative can be just so drastic. Oh, you guys, we got a lot of questions here. I'm in an LP in several apartment syndications. Do these go into a trust? So, okay, so if you have an investment, like with us, like with multifamily or real estate debt or whatever, there's no place to designate your beneficiaries, like you would if you had a Vanguard account or a Fidelity account, or even if you had a 401k. Okay. So this is gonna, if you pass away, whatever however they're titled and whatever your documents say, your living will or trust. Sorry, I keep saying living will. Either your will or your living trust, whatever those two documents say, whichever one you have, that is how those assets are going to pass. Okay. So this is where a lot of people up front, if they're titled to your trust, great, they stay in your trust. Now, some people want an added layer of legal protection, top-down legal protection, not bottom-up from the asset legal protection, but top-down, because your trust isn't going to offer that for you. Like if you go out and you get in a wreck that's at fault, somebody could still sue your trust and get control of your trust. Okay, so the trust is to avoid probate. It's not to avoid legality. So some people actually will have an LLC, some sort of LLC structure, and that the trust is the end beneficiary of that structure. Then, if you pass, they stay in that LLC, and according to your operating agreement, ownership moves up the chain, and eventually your heirs will get it. Now, so what I'm trying to say, let me put a pretty little bow. It's however it's titled, and whatever those documents say, that is where, those assets go. So I have a webinar, you guys can reach out to me, that's on how to invest in a syndication. What are the 3 different ways? Do you want to do it solo, jointly, or through an entity? And so I walk you through like a decision-making process to help you do that. And you can reach out to me on that. Whitney@passiveinvesting.com. How does the trust handle the syndication investments? It's just if you wanted to put the syndication investments into the trust, you can. That's just how they're titled. They would just be an asset owned by the trust. I would imagine most lawyers are going to want the syndications in an LLC, some sort of LLC structure, whether it's, not to complicate things, whether it's like an LLC that's held by a holding company and the holding company is held by the trust, or if it's just an LLC that's titled to the trust, they're going to want to see eventually those syndications in the LLC. Here's the thing. Lawyers love creating complexity, not because complexity keeps other lawyers from suing, right? There's a strategy behind it. Okay. Now, complexity can also be expensive, right? You're adding additional setup costs for LLCs, and then you've got your registered agents, annual fees to maintain minutes and operating agreements and registered agents. And so if you just have say 1 to 5 or 1 to 10 syndication investments, and you're not like a doctor or a lawyer or, in a profession that's going to get sued, and you don't, drink and drive, and you're not probably going to, be in a situation where you're going to put yourself at extreme risk, then maybe you just titled them to the trust. You can do that. I started off that way. And then when I reached critical mass, my lawyer said, okay, Whitney, stop titling to the trust. We're going to go back to these operators, retitle everything to an LLC. Okay. And you can do that. It's not a fun process. And it's not hard. It's not difficult. It just takes time. But even if you started off with assets titled to your trust, you can come back in future years and say, can we now move it from my trust to an LLC? And most operators will have a mechanism to help you do that. All right. Would you advise using KKOS for something more complicated, like implications of prenup on estate planning? I don't know. You'd have to talk to them. They have they have kind of their real estate niche. I will say my lawyer there has been very good about telling me, this is in my wheelhouse, this is not in my wheelhouse. And if I have a situation that is outside of his wheelhouse, he will connect me with another lawyer or make a recommendation, who I speak with. So I feel very comfortable about that that if I had a question that was outside the norm, that they would refer to me. So most lawyers will do, if you're new to them, they'll do like a 1 hour consult and, with you, or like a half-hour consult. Now they're not going to give you any advice. They're just going to listen to you and say, hey, we can help. And then let's set up another meeting and I'm going to tell you how I'm going to help you. Right. So, but what you're trying to do in that first like initial consult is not to pump them for free advice, but to really figure out, do you guys have a trusting relationship that can be built here? And can they actually help you? Is what you need in their wheelhouse. That's all you're trying to do. Answer those two questions. To continue my question above, when the sponsors sell the properties and I'm no longer an LP, or when I dispose of a rental property, why I need to remove these properties from the trust? Oh, so when you sell an asset, it's going to be removed from the trust because the trust is no longer an owner. So let me know if I'm like missing something there. So, yeah, you would just, keep documentation. Like you're going to keep a running, everybody here should be tracking their expenses, tracking their income. You should have your own profit and loss statement for your personal investing business. I know I said that. And that is the number one thing that I run into. Most investors do not do. They are probably making really good money, but they're wondering why they don't have more to invest. Okay, so track. It's kind of like if you want to figure out how to like lose weight, start keeping a health journal and writing down what you eat. And I guarantee you, just by that act alone, you're going to change your behavior. Same thing with tracking your income and expenses. The second thing every investor should have in place is a balance sheet, okay, that lists all of their assets and all of their liabilities. Okay, so at the end of the day, you can track your net worth. All right, so to answer this question the way I see it is when that, LP position exit, or if you have a rental property under your name and it's titled to your trust and it exits, you're going to back out that line item on your balance sheet because it's no longer there, right? It's sold. You can move it to a sold position. Like I'm a geek. I keep track of all of those LP positions that I've sold, all of my rental properties that I've sold. But I do back it out on my balance sheet because it no longer exists. And so it's therefore no longer titled to the trust. It's gone. Now, if I'm missing something there, let me know. All right, guys, great questions here today. If you have any more, feel free to reach out to me at Whitney@PassiveInvesting.com. I'll hang out here for another minute or so. And we can go through some additional questions if you guys have any. Just to let you know, we actually will open up a conversation about cash flow life insurance next week. If you've seen the marketing for it, it's going to be marketed towards business owners. But if you're interested at all at like permanent life insurance, kind of like building your own home personal bank, definitely is, everybody will get value from it because if you're investing, guess what? You are a business owner. So even if you're investing passively, you have a passive investing business. All right, guys. Well, thank you so much for spending your time with me here today. As always, thank you for, investing in yourself. If you have any additional questions, feel free to reach out to me at Whitney@PassiveInvesting.com, and we shall see you next week.